This matter comes before the court at this time for essentially a hastily called hearing on an emergency motion for temporary custody orders that has been very recently submitted by Ms. Schooler on behalf of her client. Counsel, I know part of this mess was probably created by this court's reticence to issue temporary orders in this case. I just want to comment on that. The court wanted to discourage the very type of piecemeal litigation that we're engaged in today. I also had intended that the court's declining to issue temporary orders would lead to fostering a spirit of cooperation and compromise and perhaps some joint parenting decisions, perhaps even settlement of the parenting issues before we go to trial next week. I also was cognizant of the fact that we had a relatively prompt trial date, but here, less than a week before our trial, we have what appears to be a material dispute as to what's going on with these kids. Ms. Schooler, do you have any new facts to add to your written motion?
Your Honor, I do have one fact. In the criminal case with Mr. Presbeal under GW 2024 CR 96, a part of his plea agreement was that he was not to have contact with the victims except for Sydney Simon after a batterer's intervention program is complete and may exchange children strictly limited to the exchanges. So the chance of them being able to co-parent and try to negotiate was severely limited for good reason by this Greenwood County criminal case.
I see. Well, they can communicate through counsel, certainly.
Certainly, Your Honor. I just want to make you aware of that. I'm not sure that you would have been cognizant of that.
All right. Fair enough, counsel. Mr. Wood, Ms. Schooler lays out in her motion a fact pattern which is on its face quite disturbing to this court. It appears that Sydney Simon has been a long-term de facto custodial parent. While I realize that there's no temporary orders that he has specifically violated, I also would reflect that he's gone into a school week now and apparently withheld custody from the mother and not sent the kids to school. Do you have an explanation for your client's actions here?
Well, I asked him about the school. He said he had a family emergency for, I think, the 2 days that they missed. And so
what's a family emergency?
I'm unsure what that family emergency is, Your Honor. He just told me family emergency. I tried to get him on to do this recording so he could testify and tell you, but since we only had about 5 minutes lead time, it was difficult to get him on.
I understand that, Mr. Wood, and I certainly am sympathetic to your situation here, but what I was really just looking for is some plausible explanation as to why these kids have been pulled out of school by him without the consent of the mother in this case, and why he just didn't simply return them in what I thought was an agreement between the parties regarding an exchange time back to mom.
He thought that it was 50-50 and he planned on returning them back tomorrow tomorrow at 7:30. He thought that was what the agreement was on a 50-50 parenting plan that they had talked about, but I'm not sure what they talked about exactly.
All right. With that said, Ms. Simon, let me address you directly. Where are the kids attending school?
West Elk. It's in Howard, Kansas.
Both kids go to West Elk, the same school building?
Yes, all three of them.
Okay. All right. Okay. All three of them. As I understand the motion, they've been returned to school about midday today?
Yes, that's when they called me about 12:03.
Is there any reason you can't pick them up and take possession of them after school?
That's my plan after we get done with this hearing.
All right. Well, some of the edge has been taken off by the return of these kids to their scheduled school. The real issue now is what happens to the kids between now and time of court. Just based on what's currently before the court, this court has concern that the father in this case will not comply with a directive from the court or any agreement made. I think that his actions this week are not well explained. And again, Mr. Wood, I do understand the nature of today's emergency proceeding didn't give you much time to prepare. But based on what's before the court, this court is going to order that the mother just take physical possession of the children after school today and maintain that undisturbed until our hearing date next week. That way there's no more exchanges. There's no more parenting time issues that should rise between now and next Wednesday. We are scheduled to go to trial in Howard, 9:00 a.m. on Wednesday, May the 7th. At that time, the court can make appropriate orders regarding parenting rights at that time. But until then, Sydney is to remain the sole factual custodian for these kids between now and time of court. And Ms. Simon, I want them in school.
Yes, sir.
I don't think that's an
Okay.
issue with you, right?
No.
Okay, I didn't think so. And there's some other issues that we also need to sort out next Wednesday, unless some of these have been settled. Ms. Schooler, have any of them been settled?
Not at this time, Your Honor.
Have you conferred with Mr. Wood about them?
We, briefly.
All right, I would encourage counsel to have further discussions regarding possible settlement, at least some of the issues in the case, to try to narrow things down between now and next Wednesday. But I
Absolutely.
will also observe here that I've entered an order that an agreed pretrial order be submitted by May the 6th. I didn't, the note doesn't say who is to prepare that.
We're working on it, Your Honor.
Okay,
We are.
I appreciate it.
Ms. Schooler sent me some information. I'm trying to get the additional information for my client. And so we're trying to get that done hopefully tomorrow.
All right. In recent times, has there been some communication allowed when the kids are at Sydney's home with their dad by email, text message, phone calling, anything like that?
I think there's been some phone calls, I think. Maybe Sydney, Simon could tell us, I don't know. I mean,
I would defer to my client, Your Honor. I apologize.
Sydney?
There has been some communication through text about like exchanges and pickup times at the sheriff's office. I've asked him to get a parenting app a while back so we could
Okay.
communicate on that, and he
I want to make
refused.
sure you understand the court's question. I'm talking about contact between father and children.
Yes, there has been contact. I was going with every other weekend, but we've had some struggles like we have this
Okay.
week with that.
Do the
So,
kids have their own phones?
no.
Okay. Well, what I just want to give you some direction. Some sort of reasonable once a day telephone contact, I don't necessarily feel is inconsistent with the kid's best interest or the orders of the court. If he wants to remain in some sort of communication, some short phone call with one or more of the children certainly seems appropriate between now and time of court.
Okay.
He would
Yes.
have to call your phone, right?
Yes.
Okay.
It was.
All right. Well, again, I would just ask you to be open-minded about allowing some limited telephone conversation between father and children if that's what he wishes to initiate.
I can do that.
Okay. And he has your phone number, right?
Yes, he does.
Why don't you guys just cease the hateful text messaging that some of which I think were kind of attached to this motion as an exhibit or were related to this motion as an exhibit. I don't really get the impression that any communication between the two of you is, without your attorneys being involved, is going to be particularly fruitful for now. So let things settle down and we'll try to sort things out in court next week. Okay?
Okay, sounds good.
All right. Ms. Schooler, is there anything else that we need to particularly address as part of this proceeding at this time?
Your Honor, when you stated sole factual custodian of the children, I just have a slight concern with the school. Are you going to put that within a disposition sheet or anything like that, or do you want me to prepare something as soon as possible?
I'll want you to prepare something.
Okay, I
Can you
can.
get
I
an
just.
order to my queue.
I can do that. Can we? Would you like language? Just because teachers, school staff aren't attorneys, I don't want them to. I want it to be clear that he's not to pick them up from school unilaterally or anything like
That's
that.
consistent with the court's order.
Okay.
I mean,
I have
we're
no
only
further
talking
questions.
about 3 or 4 more days where that's even relevant. But that's certainly consistent with the orders of the court. He's not to pick them up at all, much less from the school itself. And if the order needs to say that, then the court certainly approves that language.
Thank you, Your Honor. I have nothing further.
All right, Mr. Wood, again,
Nothing
I
further,
understand
Your
your compromised position here this afternoon.
I
Is
understand.
there anything else that you would express to the court at this time?
No, Your Honor, not at this time.
All right, then council, I'll plan on getting the agreed upon pretrial conference order. And then we're gonna see you in Howard for court at 9:00 a.m. Wednesday, May the 7th.
Okay.
Thank you,
Thank
Your
you.
Honor.
Thank you,
Thank
council.
you.
All right, if there's nothing further, this matter is in recess at this time.